And you have the right to plead your case and ask for mercy from the court news. A court decided that you didn't have the right to plead your case and beg for mercy and denied a defendant the right of allocution. So this is one of those things, that's sort of one of those bare basic rights that a defendant has. You have the right to testify, you have the right not to testify. You also have the right to allocute or not. So it's usually the very last thing that happens before sentencing. It doesn't necessarily have to be, but most trial judges seem to do it that way, right? So after we hear from all the other victims, after we hear from all the other people who want to say something, the last word goes to the defendant, who has the right to get up there and beg for mercy or, say whatever they want for the judge to consider. And, this is actually a right that you actually have to honor. So when you don't do that, bad things. So how about let's do a do-over on the sentencing because you didn't give the defendant the right to actually address the court. So that's a problem. Let's get started with this. From the case of U.S. versus Johnson decided Thursday by the district judge, because originally the trial happened before the magistrate judge. So we have appealed, although we're using the term loosely, from the magistrate judge to the district judge. And the district judge is going to review what happened to the magistrate judge and be like, no. So the trial judge is like, eh. So on March 27th, 2021, Mr. Johnson was involved in a car accident. Johnson was taken to the hospital where a blood test confirmed the presence of PCP and marijuana. Well, that seems some relevant evidence as it might relate to the car accident. Maybe that indicates that he was perhaps under the influence of substances that might have impaired his ability to drive. That is a problem. On December the 21st of 2021, Mr. Johnson pled guilty to driving under the influence of the controlled substance, otherwise known as DUI, and also driving on suspended license. So he already had a suspended license and, so there was that. So DUI, suspended license, and whatever. All right, so sentencing takes place March 23rd, 2022. Before the proceedings were underway, the United States magistrate judge, which is conducting this trial, which you can do with permission of the defendant. So magistrate judges do a lot of things, and sometimes they hear entire cases. It's depending on the availability of district judges and depending on whatever else, you can have your case heard before a magistrate judge if you want. So we're going to do the trial before the magistrate judge. Fine. The United States magistrate judge took a brief recess to review a pre-sentencing report, the emergency room report from the night of the accident, and a letter reflecting Johnson's participation in substance abuse treatment. The magistrate judge next heard from the government, who requested that they sentence Johnson to 60 days of incarceration on DUI and 18 months probation on suspended licensing charge. As grounds for this, the government cited Johnson's prior suspended license offenses and the seriousness of the accident to which the intoxication contributed. So how about 60 days and an additional 18 months? Okay, that's the government's recommendation. The magistrate judge then turned to Johnson's counsel, who highlighted that Johnson was voluntarily participating in outpatient drug treatment because at this point it hadn't been ordered, right? Because he hasn't been sentenced yet. So we're doing the drug treatment voluntarily at this point in a way to try to show that we're taking some accountability, which, you can judge for whatever value you believe it has, but they'd like you to take note that we're doing this voluntarily at this point. That he's the primary breadwinner for his family, and his prior driving offenses were relatively minor. So although his license might have been suspended, in the grand scheme, not a big deal, which, one can judge for themselves about that, but that's what they'd like to argue. Counsel also urged the magistrate judge to adhere to the pre-sentencing report recommendation of probation for both DUI and suspended license. So the pre-sentencing report, which conducted typically by the probation office says, how about probation for both offenses? The U.S. government over here is like, we're not really happy with that recommendation. From the probation office, we'd like some jail time. So the defense counsel's like, you know what? The pre-sentencing report, that's just the best report ever. We really think they got it right. We really think that you should go with the probation for both offenses. All right, so that's what's happening there. The defense counsel also put direct questions to Johnson about his job, his current treatment program, and financial obligations, to which Johnson responded, but didn't elaborate. So counsel for defense asked the defendant some questions. The defendant gives some answers, but no particular elaboration. When counsel had concluded his remarks, the magistrate judge announced that he was sentencing Johnson to the statutory maximum of 6 months imprisonment on each offense to run concurrently. So the probation office was like, how about probation on both offenses? The U.S. government was like, how about 60 days? The judge is like, how about 6 months? Because sentencing is in the discretion of the judge. So the judge is like, how about the max? How about 6 months for both offenses? I'm not all about that 60-day life. I'm not all about that probation life. How about 6 months you get? As grounds, the magistrate judge noted the offense ranks as one of the most troubling cases they had ever heard. The magistrate judge further advised Johnson of the right to appeal, and he must report to the United States Marshal to begin his sentence on April the 20th of 2022. At this point, defense counsel stated that Johnson wanted to address the court, asking, "I don't think you really asked." Right? The judge has pronounced sentence, and we never bothered to ask the defendant if they had anything to say. Would it have made a difference to this magistrate judge? Who knows? But either way, it's a right of the defendant, right? You have the right to address the court. You have a right to get up there and be defiant. You have a right to get up there and beg for mercy. You have a right to basically say kind of anything that you want at that point. What would you like the court to consider as I'm considering what to do with you? And we didn't ask, and that's a problem. The magistrate judge responded, "Go ahead," although the record's not particularly clear as to who they were addressing at that point. So it's okay, well, sentencing already done, but you want to address the court? Sure. Yeah. Johnson briefly stated the drug program really woke me up. I haven't used PCP, no nothing. I mean, my mind is focused. You know what I'm saying? And if anything, can you just give me like house arrest or anything? I mean, I support my own family. Nobody here to help me. The magistrate judge interrupted Johnson to explain that he already reached his decision. Taking into consideration not only your status financially, but your environment and where you lived and who you lived with. So the magistrate judge isn't like, "Oh, geez, what a silly mistake for me. I forgot to ask. That's such a stupid mistake. I can't believe I did that. Okay, let me reconsider. Please, please give me your best plea." And then no. The judge said, "You know what? I'm not even going to let you finish. I'm not even going to let you finish," says this judge. So even worse than Kanye. I'm not even going to let you finish. I've already reached my decision. Johnson timely noticed his appeal, which raised one issue, that the magistrate judge erred in denying him the right of allocution, which appeal isn't right, strictly speaking, the right word here, but let's press on because we've appealed to the district judge. So, yeah. A defendant's right to allocute enjoys a rich common law tradition dating back in American jurisprudence, dating back to 1689. A court's failure to inquire directly of the defendant if you have anything to say before sentence was imposed required reversal. So this has been a right since the late 17th century. You have the right to address the court. It may not do you any good. It may be futile, but you have the right to try. You have a right to say your piece, even if that's just for your own, state of mind, to cleanse your soul by admission. Maybe you're like, I did it and I deserve everything that's coming to me. Maybe that's what you want to say. If it is, you still have the right to say it. So you want to get up there and admit everything. You want to admit that you deserve everything coming to you. You want to get up there and beg for mercy. You want to get up there and be defiant. It's up to you. It's your right. So, okay. The Federal Rules of Criminal Procedure codifies this right that's existed for a hot minute. The rule provides that before imposing sentence, the court must address the defendant personally in order to permit the defendant to speak or present any information to mitigate. So, it says must. This is not an option. Relevant here, the compliance with the rule requires the sentencing court do more than merely afford defendant's counsel the opportunity to speak, because even the most persuasive counsel may not be able to speak for the defendant, as the defendant might, with halting eloquence, speak for themselves. So, we love you, defense attorneys and all, but in the end, it's the defendant who is going to suffer the consequences of the sentence. And so, whatever value you have as the most valuable orator of all time, in the end, perhaps only the defendant truly can speak for themselves. Or not, it's up to them. But you have to give them the choice. The rule instead commands the court must address the defendant personally to afford them the chance to speak or present evidence in mitigation. Regrettably, the magistrate judge had not afforded the defendant the opportunity before imposing sentence. The magistrate judge pronounced the entirety of the sentence, including the advisement of the right to appeal, without ever inviting the defendant to allocute. Oopsie doopsies. Oopsie doopsies. You have the right to plead for mercy, beg for mercy, admit guilt, ask for contrition, ask God for a mercy on your soul, whatever it is you want to kind of do. You kind of have the opportunity to get up there and say your piece, as it were. Before they drag you out of the courtroom, you have the opportunity to get up there and say, your last words on the record before the public. And no. So we didn't do that, so that's a problem. At the conclusion of the proceedings, when defense counsel called the magistrate judge's attention that Johnson wished to be heard, the judge simply said, "Go ahead," and then cut their statement short. The failure to address Johnson personally in advance of announcing sentence constitutes plain error. Yep, that's a problem. The government argues the magistrate judge's initial pronouncement of sentence was tentative. Oh, it was tentative. It wasn't a real sentence, and not become final until after Johnson asked to speak. The record reflects otherwise. So the government's like, it was only a tentative. It was only a tentative judgment. The judge was totally open to reconsidering things. They were totally open, and the district judge is over here like, no. Without ever addressing Johnson directly, the magistrate judge announced every aspect of sentence, to include prison terms. The terms will run concurrently and associated fees and costs. The magistrate judge even articulated why he was rejecting the recommended sentence of probation, as it was not going to help this individual and it would be a waste of time. Which, are decisions the judge can reach. They are the judge. They can reach those decisions. But, would you like to hear from the defendant first at all? No? The judge further advised Johnson of his right to appeal and ordered the sentence to begin serving his sentence on date certain. Only when the magistrate judge, in evident preparation to end the proceedings, asked anything else from anybody was the defendant permitted to speak. It's not going great. At this point, the court said nothing to suggest the earlier pronouncement had been tentative. The court didn't say, "Oh my God, I can't believe I made such a juvenile schoolboy error. I can't believe I forgot to do that. What a stupid mistake I made. Oh my word. I'm so sorry. I have to give you this. You have every right to address the court. Please let me put aside my sentence. Please address the court and tell me what it is you have to say, and let me hear your words." Didn't say anything like that. All the court simply said was, "Go ahead." Not super encouraging. Thus, the magistrate judge, having arrived at the final sentence without inviting allocution, committed error. As to whether the error affected Johnson's rights, the court recognized denial of the right of allocution by itself does not satisfy this prong. Rather, the defendant must demonstrate at least the possibility that allocution could have persuaded the judge to impose a lower sentence. On this record, the court concludes that affording the right of allocution and advance of sentence could have made a difference. So maybe if it was harmless error, maybe if this was a statutory minimum, maybe if this was the least the judge could literally do. The minimum sentence is 6 months. I'm sentencing you to 6 months. So literally nothing you say could make a difference. Then maybe harmless error, but that's not the situation. On this particular record, the court concludes that affording Johnson the right to allocute could have made a difference. This was Johnson's first DUI conviction, yet he received the maximum sentence allowable by law, 6 months in prison. That sentence was far more punitive than the government's recommendation of 60 days or the pre-sentencing recommendation, the probation's office of how about probation. So the judge over here is like, how about the max? Which, the judge can do if they have the grounds to do it, right? The judge gets wide sentencing discretion. So, rule number 1, don't piss off the judge, because the judge gets a lot of latitude. They can sentence you to more, they can sentence you to less. And as long as it, has any sort of bear on reality, the Court of Appeals will uphold it. So, there's that. Further, as Johnson's individual circumstances and characteristics, which the judge was obliged to consider, Johnson had much to say. He was gainfully employed, supported by his family, and had been participating in drug treatment for quite some time. Although the magistrate judge heard some of this during the colloquy between defense counsel and Johnson, Johnson had no opportunity to advance the sentence pronouncement to speak for himself directly to the court with the halting eloquence that only the defendant themselves can bring to bear. Yep. Thus, because the record reflects that Johnson retained at least the possibility of, some mercy, then, you screwed up. So, yeah, not going great. Thus, that brings us to the determination from the district court of the judge in the case of United States versus Johnson. This case was heard before a magistrate judge. Which, fine. As long as everyone consents, totally cool. Magistrate judges typically handle preliminary proceedings. They issue warrants. They do that kind of stuff. They typically serve more of an assistant role. But if everyone agrees, then how about the magistrate judge? And everyone said yes. So fine, we're going to do this before a magistrate judge. That's perfectly fine. And the magistrate judge said, I hereby convict you. And the defense like, wait a second, I had some things to say. And the judge is like, lol, get wrecked. How about 6 months? And the district court, reviewing this decision from the magistrate judge, is like, yeah, no. You kind of have to give him a chance. In the end, maybe you can do this in the end. But, you have to give him a chance to literally plead his case. He didn't get a chance to plead his case. So, no. So not so much with that sentence. How about a sentencing do-over? And perhaps that sentencing do-over will be heard by the district court. Who can say? Because of how well this has been going. But the sentencing for the moment is vacated. And that brings us to the end of discussion of this case.